Okay, hi, my name is Rick Kwan. Most of you know who I am already. Welcome to this session number 3 of the Space Entrepreneurship Series. The way this thing got started, believe it or not, was some prodding from one of the AIAA members on the council, and somehow, anyway, SVSC took up, particularly Sean took up the challenge to, how do we get entrepreneurs going. So I thought I would make a few announcements both on the SVSC and the AIAA side first. So you obviously are here for this meeting tonight. Surprise, tomorrow evening, right? Tomorrow evening there is a dinner meeting for, how many of you don't know what AIAA is? Okay, so AIAA is American Institute of Aeronautics and Astronautics, and that's like ASME or IEEE or whatever it tells for aerospace. There's a meeting tomorrow at Michael's at Shoreline. Guest speaker will be Michelle Evans, talking about, she's written a book on the SES2014 project, which looks like it's going to be the authoritative historical book. She interviewed pilots, a lot of the engineers. She grew up around, Dryden or Flight Research Center, as it was called at the time. So she spent 15 years, something like that, doing the actual research for the book. So that actually is tomorrow, and if you go to the AIAA website, AIAA-SF.org, you'll see that there. So that one is tomorrow. We got a bunch of stuff going on. May 29th, which is a Thursday, we have a tech talk. We do these tech talks from time to time on these, well, more technical subjects, obviously, on things that people might be able to use in aerospace projects. So some of you are familiar with a product called STK, right? What used to be called Satellite Toolkit, now called Systems Toolkit. And the reason it's called Systems Toolkit is because they've now gone into other types of stuff like this. So the upcoming talk will be on UAV and aircraft missions and how they've adapted STK to do those types of things. So we'll get some demos, and last time Roger Martinez, who does the training on this stuff, last time he was out, he actually told us how to download STK for free, so you can try this stuff out. Examples you can use, so we'll probably have a little bit more of that as well. So that's Thursday next week, and then we're trying to steer clear on Memorial Day. When we get back on June 10th, we will have the final session of this series on business campus. Yeah, that's right. And then a bunch of this, we're hoping that there are a few people in the audience who have ideas that will be good for a space startup weekend, which hopefully will be coming in July. Details to come.
I think it's going to be the weekend before the New Space Conference.
Okay, which would make it, I think, July 18th.
19th and 20th.
Yeah.
Friday, Saturday.
And then what we'll have, the space exploration symposium will be the Monday and Tuesday of that week, and then Wednesday, Thursday, and Friday will be the New Space Conference. There's something, these three things will be back to back. And I probably don't have any more to say. I'll let you guys.
Sure. Okay. Great.
So we'll add that.
Yeah, good. Well, thank you very much for everyone that showed up. Hopefully you got I would offer some more, but apparently we did a better job of not having so many leftovers. But anyway, a little comment about Sandbox Suites, where we've been meeting here. Certainly, if you guys are interested in desks and availability for offices and everything, be sure to let Tiffany know up front, who's our host. While we're here, Silicon Valley Space Center is located in Sandbox Suites, and we've been here since the beginning of the year. This is the third talk in our series. I believe I still have to get the slides together for Rick from our last series as a PDF version to send out to everybody, but we'll take care of that at the end of this. I've also been encouraging everyone to submit their comments on SurveyMonkey. That hasn't been very positive. Or no, the comments, it hasn't been very effective. The comments have been non-existent. A hard copy version that you guys can fill out afterwards. Let me know what you think. But since that people are still here, it obviously can't be that bad. For Silicon Valley Space Center, Lee Colin is in the back, and Lee, if you have any questions about Silicon Valley Space Center or membership options and things like that, be sure to talk to Lee. Lee also has a discount code for Sandbox Suites if you're interested in some convenient office space. And as a reminder, the first session we did was on startups and then markets and customers. I think we had a really good discussion about focusing on customers. I find that in the new space area, it's no matter what your company is, it's really important to understand customer issues, because without customers, you're not going to have really much of a business. And so today, I talk about competition and IP. You might say, well, what's really the relationship of those? And that is because IP is really a barrier to entry to keep other businesses out. And before I get into the rest of this, I'd like to introduce a couple of people. We've got two guests that are here today. Jennifer Perkins from Canopus. And maybe you guys tell me a little bit about Canopus and what you guys are doing.
Sure. We are a small satellite company. We just are ready to launch 2 6-unit CubeSats. They'll be launched June 19th. They're doing AIS. It's more of a kind of our first tester, and over the next year we're hoping to launch between 10 and 16. We have 2 constellations that we're putting together, so we're kind of mid-frantic. We've been in this area for less than a year, and the company is actually the same age. We ran another one, so that's where we're at. We're located over at Moffett.
The ones you're flying right now, those are 6U or
6U.
And then the Constellation, are those also 6U?
I believe so at this point. They're still designing.
Yeah, fantastic.
As we go.
All right. And Jai Hughes is one of our other guests. He's from Experience the Game, and maybe Jai, you can give you a brief synopsis of what your company is.
I'm actually Experience Technologies is the name of the company.
Oh, Experience Technologies.
And Experience the Game is our core product. So we've developed a game platform that's more than a game. It's more of a communication, relationship building tool, ways for people to come together at deeper levels for what we call game storming. We actually trademarked the concept of game storming instead of brainstorming. And so many different processes, from conflict resolution to having fun, getting to know people on a deeper level. And it's a card game, board game, web game, online social network, virtual reality. We're developing a video game version of it, and so it's a pretty robust platform for better communication in the world.
Oh, great. I'll hope to hear more about that. And for our guests for today, as you know, as part of this series, always have a guest speaker, and our guest speaker today is from Perkins Coie. It's Lowell Ness, who I know from our work on Silicon Valley Space Center, and Jordan Becker. And I'll let Lowell, what I'll do right now is just talk for a little bit about competition, and then I'll introduce Lowell, and Jordan will take care of the legal and IP issues. So that's all. And our next session, as Rick mentioned, is on business models. And again, the Space Startup Weekend is going to be in July. It's going to be the 18th, 19th, and 20th. We're not quite too sure of the venue. Probably here at Sandbox Suites. Might be at another location, but it's the weekend before the New Space 2014. And there you're actually going to have a lightning pitch competition. I don't think they're going to have a business plan competition this year because of NASA funding issues, but my view is that if you're here in Silicon Valley, you're already in the world's biggest business plan competition. So it's good if you're from out of town to come and participate in the business planning competition, but if you're here, this is where the action is. So as a reminder for what we talked about the first time on startups, one is really just being prepared for the startup process. One, making sure that you've got enough runway, enough cash in hand to make it through this process, and 2 is, in building your team, because your team is as important as your product and your customers, because these are the people that you're going to be working with day in and day out. So, and a comment about market technology risk, we'll talk about that next time. And then from the second session on customers, it was really putting the customers first. This is, for engineers, it's not about the technology, but it's really about what do your customers need and where's the pain point. That's what investors want to hear. and taking the opportunity to test the market and get your product out there and figure out what do you really know, because you have a bunch of hidden assumptions about what you think the customers want, and you've got to develop the quote minimal viable product and get it out there and query. And I think that is an activity. The whole lean startup model is something that engineers and scientists can understand, that you've got a bunch of assumptions that you have to develop. So another issue on here is that what happens is, yes, you run out of money, but what you really run out of is the number of pivots that you can make in your company. So when you go out and say, hey, here's what we think the market is, you're really running against how many pivots do you have before you run out of money. So you've got to try and make as many adjustments to your business plan based on what you've learned. And certainly, I find selling is hard. It involves getting out of the office, involves talking with people. These are not things that, whether you're an introvert or an extrovert, you've really got to focus yourself, not just talking to people, but really listening to what customers want. So in thinking about your business, you might ask, well, why does what makes my business? What defines my business? And you could look here and you could say, oh, well, here are all these things. Gee, I've got some vision about where the industry is going. I've got a mission that our business is really in. I've got the values. What are the core principles that we use? What are the things that we really believe in as a company, and then long-term objectives as our goal. But I would say that these things, yeah, these are all great to know about your vision and where you're headed, but your business is really defined by your competition, because you have to know, you can know all these things internally, but you really have to know about the things that are around you, the things that are not only in your space, but also everything that's part of operating as a business. Some of those things are captured in what the MBAs call a pest analysis, which is not supposed to be pesty, but covers these things. And actually, there's a mistake here. This is actually supposed to be economic, but looking at, I'm doing my business, but what are some of the other things that are important about it? And I mentioned this last time in terms of, as you're talking about your customers, but you want to think not only what am I doing, but what's the environment that I'm operating in. And that can consist of the political environment. What is the sentiment of people? What are some of the political challenges that might happen? And, here we're in the aerospace industry. Part of the political environment will be, gee, are people really for or against privatized space program? We're in a time where I think people are saying, gee, we need to have less government and more private opportunity, and so this can actually be a boon for anybody that's coming in and saying, gee, I want to go start a space company, and kind of playing to the program. That could change. If you look at what's happening in the Soviet Union, the Soviet Union, but yeah, you think, again, you listen to Putin and you're like, oh my God, what's like it to be the Soviet Union? But, the environment is changing because of the Russians' reaction to trade embargoes with Russia. And so the United States is locking up funds associated with Putin's collaborators. At the same time, the Russians are responding by saying, hey, we're not going to sell Russian engines to U.S. companies. And so how is that? That's an important aspect. Certainly it's a benefit to SpaceX, and it's kind of a detriment to UAL. So you'd like to look at, as you're looking at your business, what's the political aspects in this, the economic aspects of, hey, we've just gotten out of 2008, which is a tremendous downturn in the economy. Was that a good time or a bad time to start a business? Well, in terms of everyone getting laid off and having lots of unemployed people, hey, that sounds like a great time to start a business because labor is cheap. At the same time, interest rates are low. If interest rates go high, then their cost of capital is going to go up. And if you're trying to get money, it's actually going to work against you. So you want to think about what are some of the economic issues with that. Social, how do I interact with the people around me? What are other people thinking about startups? And clearly technological world, technological people, and there can be benefits. I mean, certainly, like an example is the small satellite community. They certainly benefit from the technology that's coming out in cell phones. There's a couple of companies that are here in the Bay Area that are doing 3D printed engine technologies. And so, actually, I think we've got a session in July from the California Network for Manufacturing Innovation, talking about how manufacturing innovations can impact the aerospace industry. 3D printing is one of those. So those are some of all the things that you can take into account in analyzing your business. As I mentioned before on Steve Blank and market risk versus product risk or technology risk, that's captured in a matrix like this. And I was, before the talk here, sort of thinking of some examples. But as you look at this, each one of these intersections between existing markets and existing products, this defines a particular strategy that you would want to develop. So for existing markets, if you're a company that's taking existing products and channeling them into existing markets, you've really got to think about what's my strategy for penetrating those markets? What's my strategy for carving out a space of market share where perhaps I don't have any, or how am I going to grow my market share? And that's pretty much a well-identified problem. But I would ask whether people have examples of new space companies that fall under these various categories. Certainly United Launch Alliance, even though it's a monopoly these days, when you had Lockheed and Boeing competing with one another, they were basically existing products channeling into existing markets, the government launch services. And you might ask, well, SpaceX, what was SpaceX? And SpaceX might say that SpaceX was here with an existing, essentially an existing product, a product that they were developing with an existing market. Or would you say that SpaceX was actually a new product? Because it still is just standard launch technologies, but was it a new product because they had an innovation on how they were making it? I mean, the way they decided to compete in that market was compete on cost. And so United Launch Alliance, when they do their launches with the Air Force, those launches are about $400 million a launch, whereas SpaceX is coming in and saying, hey, we're $100 million a launch. So by competing on cost, they're able to get market penetration on that. But I would ask, does anybody have any examples of other new products and new markets, or where would a company like NanoRacks fit? Is NanoRacks is that a new market, or is that an existing market? Any suggestions or comments or thoughts on the matter?
That feels like a market for which there was a demand, but there was no outlet, right, at one time. There was no way to actually put things into the, well, okay, so in some ways you can say it's a new market if you're going into the ISS environment as opposed to launching on the outside. It's a low cost path for that.
But for instance, their CubeSat launcher, right? Is that a new product?
So that, I kind of compare that in some ways to SpaceX in terms of, in both cases, you're doing hopefully a lower cost route to an existing problem. Right? I mean, the SpaceX launcher, there is some new technology they put in there, but they're solving the same kind of launch problem that people have had, but supposedly with the computerized controls and stuff, they're making their stuff cheaper. And in the case of
So where would
NanoRacks, they're piggybacking.
Where would you put NanoRacks in?
So, let's see, yes, where are they going with
So I'd argue that it's clearly a new market, right? You're selling launch to grade school science classes, grad students, people who were never in the market to buy a launch capability. So it's a new market. New product because nobody ever really had a product that would launch a CubeSat.
Yeah, so you would put
I
them
put 'em
down here. I mean,
down
this,
there.
it says diversification on that, but that's, this is this whole area of, gee, if I was Steve Blank, the last thing I want is a new product in a new market. Right, because that's part of the NanoRacks challenge. You might say like secondary launches of CubeSats. Secondary, if I bought a secondary ride on an orbital vehicle, right, that might be a new product, or that might be a new product in an existing, well, depends on whether you consider CubeSats to be an existing market or not. Whether it's, it used to be a new market, now maybe it's an existing market. Maybe when Bob Twiggs was creating CubeSats, maybe it was down here, and now what's happening is that CubeSats are migrating from new markets to existing markets. And so that when it was a secondary launch, it was actually a new product for a new market, but now it ends up being it's a new product for that company, but it actually ends up being, what's turning into an existing market.
Seems like there can be a lot of crossover, and maybe sometimes they rely on that to provide some insurance for themselves. Like the Skybox is developing, I mean, it's an existing product, space imaging, but they're making it a new product by making it high frequency space imaging. And they're going to obviously sell it to people who already want that sort of thing, but they also hope that there will be new markets for, once this new type of data is available.
Yeah.
Just like once GPS data was available, there's all sorts of stuff we can do with it now that wasn't there before, and I think they are counting on, the existing customers for that type of data, but also for new markets that will come out once this sort of thing is available. Then more people will want it for other things that maybe no one has thought of yet.
So Skybox is an example of, for the people that already buy satellite technologies, but they offer a different product in that. Asteroid mining, right? Probably an existing market, but with a new product. Or is that an existing product in an existing market? Maybe that's what it is.
It's mining.
It's mining, right? It's using minerals, right? Unless you're
Serving an existing need.
Lee's got to shoot me here, but unless you're providing unobtainium. Right? And I guess it's an existing product in an existing market, which makes market penetration a real challenge. So you can kind of think of, and I don't know if there are any other Clyde space. I guess Clyde space, what we have is CubeSats are sort of marching up here, but I would say the education guys like Cube Labs for the ISS, that's clearly a new product, but is that an existing market? Maybe it's an existing market for educators. Educators are an existing market, but maybe for space, they're kind of a new market. Anyway, but you can kind of, when you think about your business, you can say, well, where am I? And then based on here, you can say, well, gee, I've got to, if I'm in this part, I've got to figure out how I'm going to penetrate the market and carve out space for myself. Whereas if I'm over here, new products, hey, I've got a big challenge on product development. How am I going to make sure that those things work, whether it's Clyde Space, anybody that's manufacturing small satellites, I've got to get the technology work. Whereas here, it's, if I'm taking existing products, this might be, taking existing satellite systems and selling them into some new market, which might even be, using new markets might be satellite data applied to developing economies. How do I actually go out and do the market development so that people are aware of that? So, but I wanted to put this as an example there because it shows that as you think about your business, you can sort of define how you relate to the competition and some of the things that you want to think about. And one of the key leaders for strategy development out of the whole business program, with people taking issue with Michael Porter on a bunch of different topics. But Michael Porter is pretty much the person out of Harvard that defined competition. And you know, for one name to remember out of this is certainly Porter, and all of the various articles, books that he's published on this. One of the slides I didn't cover on here is Clayton Christensen's disruptive technologies, which is also another topic. But disruptive technologies are like, hey, if I make all these decisions, if I choose to operate my business based on all these competitive strategies, and I still run into trouble, why is that? If I've made all the right decisions for the right reasons, I still run into trouble, and that's where disruptive technologies and the innovator's dilemma come in. But in just talking about, again, that sort of space of thinking about competition, normally you think about competition in terms of rivalry among existing firms. And that's, hey, I'm selling to a customer, you're selling to a customer, what about us? You know, this is my competition. But that's not the whole picture. Like when we had that matrix and said, oh look, you know, here I've got products and markets and I'm just a company competing with other companies. Competition is actually broader than that. And it includes not only companies, but as we started off talking about entrepreneurship, a key part of entrepreneurship is where do I fit within a supply chain? And a supply chain is raw goods all the way up to a customer. And the supply chain is basically captured in this horizontal portion of the diagram. And it says that as you think about your business and what you're doing, you have to also look at where am I getting my goods and services from? Where am I buying the raw materials that I use? So if you look at Canopus, for instance, there are a whole bunch of electronics that go into the Canopus satellites. And where am I sourcing those electronics? If I'm only buying them from one company, and I base all my stuff off of ClideSpace, then as I start scaling up my business, all of a sudden I'm wedded to ClideSpace, and I could be at a disadvantage compared to another company which doesn't have that strong reliance on an individual provider. And of course, an individual provider is called, a monopoly. Everyone that's played the game knows that that doesn't work so well. Another part is the power of buyers. And one of the things that, if you're pitching your business and you're like, hey, I've got a great idea, 90% of my revenue is going to come from the government. That's a problem with my buyer on this, because all of a sudden people in Washington will say, gee, we don't kind of like your business that much. And that can be its own problem. So as you think about your business, not only do you have to think about the bargaining, as it says, the bargaining power of suppliers, but also the bargaining power of buyers. And what's currently happening in the space business is usually the government is the sole buyer of space hardware. And that, the term for that is monopsony, which, is another situation you'd like to avoid. And so if you only have one customer, and then that, customer runs into trouble or, is unable to pay, then you've got a problem. All those things are probably pretty obvious to everyone. If you're Digital Globe and you're saying, hey, we produce a lot of satellite imaging data, and all of a sudden you've got Planet Labs and Skybox coming in, and you've got to think about who are some of the companies that are going to come in and actually compete in my area. Because once I start my business and everyone sees that all of a sudden it looks like there's a lot of money to be made in this area, you got to think about, how am I going to keep new entrants out of my business? How am I going to lock these people out? And then, of course, if you're talking about education, you have threats of substitute products or services, certainly in the asteroid. I don't know if asteroid mine's a good example of that, because here's asteroid, can I get it from space or can I get it from the Earth? But also, I think here are alternatives. And one of the classic examples is Encyclopedia Britannica versus the PC, where the Encyclopedia Britannica went out of business because people, instead of buying a book, they were thinking, gee, what could I buy that serves an educational need? And I think when you look at educational markets and where people could spend their money, they could spend their money on satellite projects, but they could also spend it on a new ice skating, new football uniforms, those sorts of things. So you have to think about what are the alternatives to people, what are the alternatives people have in buying your product. And so the gist of this is that it's not just competition within this immediate area of who's out there and who's competing with me, but it's competition above and below for new companies that are going to come in. And what are people also going to spend their money? What are their alternatives? If they buy from you, that means they can't buy from somebody else. And likewise, as you look along the supply chain, and you can have effects that if, for instance, if we look at, let's look at a company like Infinity Aerospace, which makes the nano labs. What they do is they take Arduino technology, they package it up into a cube lab that they can fly in the International Space Station, and then what they do is they actually sell that to a company like NanoRacks, and that NanoRacks delivers those payloads to the International Space Station. And in that dynamic, you can look and say, oh, well, if I'm only buying from Arduinos, then I'm kind of locking myself into a particular supplier here. You know, I'm kind of wedded. If all of a sudden Atmel has a major problem, or Atmel is not a competitive technology, I'm kind of locked out of the business. Also, with NanoRacks, NanoRacks could go back and say, hey, gee, what about if I'm buying my Cube Labs from Infinity Aerospace? That's one alternative, but what happens if I decide to buy my Cube Labs from some other company? And so NanoRacks can have its own bargaining power in dealing with you as a company, as Infinity Aerospace. Likewise, Infinity Aerospace could also say, why should I wait for NanoRacks to deliver payloads to the International Space Station? Maybe I want to move forward in the supply chain and actually strike a deal such that I can deliver my own payloads to the International Space Station. And then, of course, what are some other people? All of a sudden, Cube Labs are really popular. Everyone's like, hey, it's just a box with an Arduino processor in it. I can build one of those. And all of a sudden, everyone's in that space, and Infinity Aerospace has seen, oh, gee, there are a whole bunch of customers that are in here, a whole bunch of competitors that are coming into my box. And likewise, if I'm selling to educational markets, how am I going to convince them to buy this Cube Lab when they should be spending money on school lunches and all those other things? So as I think about my business, I have to think not only just about, hey, who else do I know today, like Valley Christian. Is Valley Christian is doing an educational program with Cube Labs. How am I going to compete against them? But how do I compete against this much larger space? That's important to think about. This next slide is an explosion of ways to think about all these issues. And I don't intend for people to read this, but this slide is here for your own information when we send the slides out. But it talks about a whole bunch of different issues. It talks about things to think about: the number of competitors, the relative size of competitors. Is the industry growing? All these different areas. The relative price of substitutes. Even here, the buyer's threat of backwards integration. I mean, Arduino's Atmel could say, hey, we want to be in the Cube Lab business too. We're going to make our own Cube Lab hardware. And, that's all of a sudden you're a small company and you're competing against a gigantic company. Likewise here, the number of buyers relative to sellers, you'd like to have a lot of people buying it. Right now, if you want to launch CubeSats from the International Space Station, you got one person to deal with, and that's NanoRacks. So as a CubeSat builder and launcher, you really have no other alternatives unless you go to some secondary suppliers. But NanoRacks may say, well, look, here's how we're going to define our niche. And this is the kind of service that we provide such that they differentiate themselves from other products that are out there. So likewise, and as you go into this, you could start really ask probing questions that explore these parameters. So it's not just a very superficial layer, but you can actually go in detail and talk about a bunch of issues that are related to this analysis of competition. This I included in terms of as you think about your business. Again, we sort of talked about, what do you do internally, what's the whole space, but then again, focusing internally on things. If you're in a business, and for startups, some of this is not really relevant, but I would make a comment that the things you want to typically focus on for what you're doing, because you're going to do many things, are to focus on those things that are for a business basically bringing in cash in some way. That where this is in terms of market share and profit. And so even if you have a low profit on some product, it could be important because you have a pretty big market share, and that you can kind of control that market. And just because you have low profit doesn't necessarily mean you shouldn't be in that business. Likewise, if you're starting off on a new business, this area over here is basically where high profit and high market share. These are things where you want to come in and you want to still maintain as much market share as possible. Basically invest in those areas, and whatever your money you're making out of here are the cash cows. You shouldn't be feeding the cash cow, but you should be making sure that this is going to continue to grow. And of course, these things over here is where you have low market share and you're not really making any money off of it. And that's kind of stuff you're like, don't even get in those kinds of businesses, where you got to really think twice, because if you were an evolved business, you'd say, hey, I just don't want to be there. And then the big question mark is where you've got low market share, but there's actually really good money to be made. And that's probably where a lot of startups end up. Yeah, Lee.
Before you slip too far away from the competitive part of it, I've heard the bestest and mostest come from you, and so I know that's part of the answer to the question I'm going to ask. But the question is that as startups, often we walk into situations where we're out of our weight class, right? We're walking in with companies that have tremendous resources at their disposal, and we're getting in the same ring with those companies. And in your previous slide, you were suggesting that one can still compete in that arena.
Yeah.
I'm just wondering if you could address that. How can one step into the ring outside of their weight class and still win?
Yeah, you've got to be really clever, and you've got to really think to what are your strengths and what are the weaknesses of the competition. There can be, certainly in terms of customers, there can be customers that the existing competition is not serving well in terms of cost, in terms of service, in terms of just day-to-day interactions. You could also look at it in terms of new customers, where there are whole market segments that perhaps aren't being addressed, that could be addressed. And we were just, I was talking to somebody about our great Zipcar example, about how Zipcar.
I was going to bring that up.
Yeah, and so Zipcar is one where everyone said, well, why is it you're going to go in the rental car business? Because there seem to be Avis and Hertz and all those guys, but with Zipcar, and what Zipcar said is, hey, there's a whole underserved market that really wants to have rental car service, and that wants it in a different form than what those other rental car companies offer. They want to rent it by the hour, they just want to show up and be able to rent the car. And so that's an example of how a new company was able to compete in that larger market space. And I think what Taylor's going to say is, yeah, I don't rent a car, but now I get Zipcar.
Well, Zipcar is like the first company that came to my head that was able to be a company that was a startup and, you know, work against other companies that have tons of resources at their disposal. So that was the first company I
And,
thought of.
you know, you could look at, you know, the Skybox story versus Skybox and Planet Labs versus Digital Globe. Digital Globe's a big company. What are they gonna do? They're gonna compete based on technology, innovation, and perhaps they're also gonna compete in markets where Digital Globe wasn't really aware that there was an opportunity there. So, you know, just because you're a big company doesn't mean you're gonna cover all the bases and that there's not an opportunity. And I think if you go back and you really think carefully about the competition and about your relationship to suppliers, your relationship to buyers, your relationship to alternative, purchasing alternatives, you can figure out a niche for your own company that is important, that will allow you to make money. And it's one of those things that, as you go through, sometimes you can sit in your office and, hey, I'll have all these great ideas, but the purpose of the minimal viable product is to get you out there so that you can ask all those questions. You can ask questions about competition. You can actually, you're dealing with suppliers and you're figuring out, hey, where am I going to get that stuff? How am I going to deal with customers? And then sit down and carefully think about this. And just don't have a gut level reaction. Hey, this is what we're going to do. Let's go do it. But and you can have a tendency to overthink things. But I think you'd be surprised as you thought about it, and you look at all the nuances, how you can turn it over and say, well, it wasn't really quite like that. And that's why I included the other slide with all the details about the, you know, Porter's five forces, because it gives you an example about how to think about things. And then on this, you know, competition is always not complete until you do some SWOT analysis, as everyone says. And this, to me, it's, you know, business is always full of all these matrices of, hey, you know, let's do this and let's do that, and then you come and develop some strategy here. But this is, I think, once you've done all those other exercises, once you know, you don't start with this, you kind of end with this, because the SWOT analysis comes from, hey, let me look at, let me first start with like that vision, mission, values and goals. You know, what are those things? What are those things that are internal to us? And then what are those things that are part of our environment, the pest analysis? And then what are the things that make up the Porter five forces? And go through those exercises before you get to this SWOT analysis, because all the things that you're going to put in here, what are your strengths, what are your weaknesses? Typically they look at and they say, all this stuff is stuff that's internal to your company, and all this stuff is stuff that's external to your company. So the threats are some of the competition that's out here, and the opportunities are some of those gaps that you're filling, that markets that aren't being shared. But you don't, I would say you don't start with a SWOT analysis, you end up with a SWOT analysis, because you think about all those other things and then factor those into these areas of your strengths and your weaknesses. So, and you could look at a company, let's pick, what's another company that we'd like to talk about? So anybody have a favorite new space company that they'd like to offer up?
Or take apart or whatever.
Yeah, something, just a comment.
Bigelow is probably good for something.
Okay,
but I'm
Bigelow.
not sure where.
All right. So with Bigelow, there, if you look at all those other things, right? I mean, clearly, you know, an opportunity is that there is no ISS replacement as far as anyone's concerned, right? A threat will be, hey, some of those other companies that have already built the ISS are, you know, can come in and offer comparable technologies, or the Russians could get together and say, hey, we're going to fly another space station. And so, you know, that could be a problem. But then again, the opportunity might be being able to come in at a lower price point, which could be a strength of the company. Whether their systems actually work or not is something else. They might have a weakness and they still have a bunch of R&D development to do on that. The political aspects of it. Political aspects are good because it's a privatized space company. The economic aspects, no, they're probably also good because the federal budget is going down. And so the government will probably want to do a COPS version of the International Space Station. Social, gee, you know, you could have a bunch of space tourists that want to participate, and you have a bunch of people that say, hey, I'd like to be a non-governmental astronaut, can I work for your company? So, and the technology, well, there could be technology innovation that's there. Likewise, so, and as you look at Bigelow, hey, they rely on launch capabilities. You know, if they only have one launch capability, that could be a real problem here. So that they probably like to have a bunch of different launch options over there. Likewise, if they don't have enough customers, that's going to be a problem. So how do you build up, you know, again, the weakness is, you know, how do I build up enough customers? So you'd like to look at all those other previous areas, and then when you get here, start filling this in. And then if you believe in Porter, he says there are really only 5 ways that you can really compete, and that's on the cost of having a lower product. 2 is differentiation, having a product that's significantly different from everybody. All of a sudden with CubeSats, everything's a 10 centimeter. You know, how are all these CubeSat companies going to compete? Innovation, well, that's certainly having kind of the next generation ahead of everybody else. And then in terms of operational efficiency, and I think, you know, for a company like Skybox where, you know, you're operating your satellite and then individuals can operate it themselves, they don't have to go through all these middlemen, that's kind of a big plus for those guys. So with that, I wanted to leave you with these slides, and then I'll introduce Lowell to talk a little bit about legal issues as it relates to IP, and that's one on specialization. And you really, as you talk about your competition, you want to figure out what area do I really need to be in? What are my core competencies based on my team? And then how can I use that as a strength to my program? When I'm competing with everybody, how is my product different from some other people? If I'm Infinity Aerospace and I'm Valley Christian, what's the difference in the offering? If they're the same offering, then people are just going to compete on price. But if I have better service, if I offer different technologies, if I offer different learning experience for students or something, then I differentiate my company from everyone else. I mean, everyone's going into asteroid mining. Okay, what's the differentiation on all that aside from the impossibility? And then segmentation of the markets. Who is it in the markets that I want to go into? I mean, who is it that really needs the product that I'm offering? Not just as a general sort of a commodity general marketplace, but how can I target those individuals that, if I look at the agricultural business, when I'm doing satellite mapping, if I look at the agricultural business, who is it out of agriculture? Is there a particular crop or something that I really need to target as opposed to just all crops, all genetically modified crops? To talk about, gee, let's go after Monsanto. What is Monsanto? And then, of course, after you've done all that, is focus on concentrating, not spreading your resources too thin. So that's what I wanted to talk about in competition, and introduce Lowell from Perkins Coie, and maybe Lowell, you can tell us, set the stage for companies and IP and a whole bunch of other topics, so that's okay.
I will do that, and you know what, I think, a long day, I'm gonna sit.
Oh, okay.
Jordan will come up and we'll both sit over here. All right, so, thank you, Sean. Just a brief introduction, I'm a corporate lawyer here in Silicon Valley, been doing this about 20 years. My role with companies is really to kind of help very early stages, you guys in the garage, dog, good idea, usually no money. And we've got a really sort of efficient way of working with startups at the very beginning, and a decent package for companies that look like they're really going to funding. So, we'll talk a little bit tonight about kind of what the startup process looks like and in focus in particular on some of the intellectual property aspects of it. Jordan Becker's a partner of mine, and he really focuses on intellectual property. So I'm a general corporate lawyer. He's really a patent prosecutor. And he'll go and make sure that patents are good, defendable, get issued. Why don't you tell them about your aerospace background?
Sure. As you mentioned, I did come from aerospace before becoming a lawyer. Worked for McDonnell Douglas Space Systems down in Southern California, which is now part of Boeing. And I was an electrical system design engineer on the Delta Launch Vehicle project. So we put up a lot of, in fact, all of the GPS satellites and a bunch of military satellites as well. I worked on the telemetry systems as well as the flight termination system, otherwise known as the self-destruct system. So that's my aerospace background. And now, as you mentioned, I spend most of my time advising and counseling clients on getting patents and building a patent portfolio, but also somewhat on dealing with threats from third parties as well.
So Perkins is really a terrific platform. I just moved from another firm where I was for 20 years, and part of the reason I did was the platform is just amazing. And one of the reasons the platform is so amazing is the IT guys at Perkins are really deep knowledge. Most big firms, this is a poorly kept secret, most big firms have one or two patent prosecutors that they kind of trot out and try to make them look like experts. But Perkins actually, I think U.S. News and World Report ranked this guy's practice group as #1 in the country last 2 years in a row. They've got it's a giant deep bench. So I don't just go get a patent prosecutor. I go and get somebody with deep core expertise in the subject matter who can actually, give you some good ideas and kind of help almost, on the invention side too. So anyway, that's my pitch for the firm. Let me give a pitch for another really interesting, fun thing that you should all be involved with, which is something called the Extreme Tech Challenge. You and I haven't talked about this, but so the Extreme Tech Challenge is something Richard Branson put together, and it's a business plan competition. I think it's going to open up in like August, and I would Google it and check it out because it's going to be a pretty cool thing that ends up with the top 3 finalists will wind up on Branson's Island in the EDI, and for a week. So, and that'll be in February. Obviously, Branson's pretty into space, so I think you guys would stand a pretty good chance, some good ideas of being up in the top group. So I would definitely look at that and think about getting into it. All right, let's talk a little bit about starting a company and what what is most probably important in the VC's mind really is the idea that the company that they're going to invest in owns something. It's not just a collection of bodies. People don't invest in service providers, right? They don't invest in law firms. They don't invest in, we saw some really interesting things happening back in the 80s with some of the boutique investment banks selling themselves and then suddenly everybody leaving. And there's nothing there. You don't own anything when you own a service provider shop, right? So having a collection of bright people isn't enough. You do hear all the time that it's team, and that's why they invest. But what they're investing in is the technology that the team is producing, because that's something that the corporation or the entity can own. And it's really that's just sort of the price of admission. So one of the things to really understand early on is if you're getting together with a group of people to start a company, is that you're going to have to assign the inventions to that company. And one of the real big sort of traps for the unwary is if you've got a day job, you've probably got an invention assignment agreement with your day job company, and you've got to be really careful about what that means in terms of crossover with your startup. And there is something in California that the statute that basically says in effect, if you do it nights and weekends on your own time, with your own resources, you're not using any kind of company databases, any kind of company assets, computers, don't use your company laptop, etc. to start your business, then there's a very narrow sort of carve out to the intellectual property assignment provisions in your contract with your existing employer. So it's something to get clear on really up front as you're starting your business, because one of the first questions that the VCs will ask is, they'll probe into the pedigree of your IP and make sure that A, it's been assigned, and B, it's clean, and it's not, it doesn't have some claim on it from somebody else. What we usually do is have a present assignment sort of built into your contract where you get your shares from the company. So as part of the consideration for the shares is going to be a contribution of the intellectual property assets. And then on an ongoing basis, you'll sign a separate agreement called confidential information which assignment agreement, or sometimes proprietary information which assignment agreement. And that will be an assignment of essentially all IP. Now you gotta be careful, that's a document to really look at carefully. There's several varieties of it. And the way I think about it, I personally, not every firm does this, but you should look at your document and see what flavor is it. For me, an employee, a rank and file employee would sign an invention assignment agreement that would effectively say every invention during the term of your employment gets assigned to the company. A founder, in my world, would sign something that says every invention related to the business of the company gets assigned to the company. That's a lot better from your perspective. If you're the founder, that's what you want. And then consultants have something a little bit in between that would say something like every invention that arises in connection with your is assigned to the company. So you just have to make sure you're dealing with the right form of invention assignment agreement and kind of read it carefully. There's only one sentence that matters. It's a long document. You got to find that sentence, see which type it is. All right, I'm going to turn it over to Jordan, let him talk a little bit about just sort of the patent prosecution process, because one of the very first things you need to do is get a provisional patent on file if you don't already have it. And Jordan, you can talk about why that is.
Sure. So a lot of you are probably already familiar with the process, so I apologize if you tell me stuff I don't know. But so basically, under the patent laws, filing date is critical. And it became even more critical about a year ago when the law changed in this country. It was the biggest change in U.S. patent law in nearly a century. We went to a first-to-file system instead of a first-to-invent system. And that put us in line with pretty much the rest of the world. And what it meant is that, whereas in the past, even if you weren't the first to the patent office, if you were the first to invent, and you could prove that, you could still get a patent. Or if the patent office was citing against you a piece of prior art that predated your filing date, you could prove an earlier invention date to get around that piece of prior art so you could still get a patent. That's no longer the case. Now it's purely first to file, so it is critical to get an early filing date. It's always been important to get an early filing date, but now even more so. So one of the things that we do to deal with that is we file provisional patent applications. We don't do that in every case. It's ideally we would file a non-provisional patent application, what I call a normal patent application. Provisional patent application is often used though when you're pressed for time or budget, because it can be done in a very informal manner. The main benefit of a provisional patent application is you don't have to have any particular format for it, unlike a regular non-provisional patent application. And it doesn't have to have claims in it. And claims are the part of a patent application that are legalese that define the invention, the scope of the invention, and that's what takes the bulk of the lawyer's time in drafting the patent application. So that's one reason we often do provisional patent applications when we're pressed for time, pressed for budget, can be done quickly and cheaply. Let's see, other,
Well, so talk about, kind of the cost and the time frame for, for a provisional patent. Like how quick can it be done and what does it usually cost to do it?
right, so, provisional patent application, it actually can vary quite a lot in terms of timing and cost, depending upon what your goals are. So, on one extreme, it can be done extremely cheaply, like for a few $100s, if the inventor or inventors have all of the descriptive materials and can provide that to the patent attorney, and it's an adequate description of the invention, we can often file that as is or almost as is. That doesn't necessarily mean that's the best thing to do. I find that it's often wise for the patent attorney to put in a few hours of time to actually shore it up and look for gaps in the description, filter out things that may be legally imprudent to include. And so at the other extreme, then, you could make a provisional patent application look just like a non-provisional patent application, in which case it would cost several $1,000s to file it. I find that the sweet spot for a provisional patent application is usually in the range of $2,000 to $3,000 to get it done. A good balance of attorney time and inventor's time and effort in putting it together. In terms of timing, you can turn it around essentially overnight if you're going to disclose it to the public, and you want to file your patent application before you disclose it. When I say to the public, I mean anybody who's not under NDA with you, with the exception that VCs are usually not going to give you an NDA, and they're usually pretty trustworthy if you're dealing with a reputable VC. So you don't necessarily have to sweat too much, although ideally you want to file before you talk to anybody else if you can. So timing, you can turn it around overnight, a few days, a couple weeks, that's fairly typical for a provisional patent application.
So, yeah, I mean, to put this into perspective, cover your ears short, you don't know. In my world, for startup companies, they're going for venture funding. There's two ways to look at it, right? You can be really focused on the actual IP itself and protecting it and trying to really build an IP strategy for your company, or you can treat it more as like a check the box kind of thing. And I think a lot of startups will go the latter route. And frankly, the VCs are largely in that latter camp too. They don't want it. It's this total dichotomy with the schizophrenia of it's super, super, super important, but all you have to have is one patent, and it just has to be on file, and it doesn't have to be granted. So you can really get there with a couple of $100 in provisional. As Jordan says, it's probably better to spend a little bit more money, a couple $1,000, to really make it actually something that could theoretically be granted at some point. The VCs will do some due diligence around it, but they're not very sophisticated about IP in my experience.
So let me just go with that point a little bit. So if your focus is short term on just getting funding, then yeah, you can treat it as a check the box kind of thing and just throw a bunch of disclosure together. But hopefully you're thinking in terms of building a company that succeeds. We all know that that's in some sense a crapshoot, right? And so if you do have a company that becomes successful, you're going to need real IP that actually has some value to it. And so to that extent, it really behooves you to put some thought and effort into your initial filings, because those initial filings aren't going to turn into a patent or multiple patents for several years anyway, most likely. And so you don't want to have to look back on it and say, oh, did I disclose this in the patent application? No, I forgot to disclose that. I can't cover so-and-so who's doing that. I really want to, ideally, think about all of the different variations upon your idea that you possibly can and disclose them in your patent application. Again, you may not be able to, you may not have the time or the funds to do that, ideally.
So I want to tease out one of the things you said, because probably some of you probably participated in this patent prosecution process before, but one of the really important things to know is that the provisional, as Jordan said, you get a year to file convert it to a regular application. couple of caveats to that. If you're gonna try to protect it internationally, for example, there's a lot of other countries out there that have slightly different rules. I'm gonna talk a little bit about PCT filing and what happens if you publicly disclose it first
Typically the process is you file a patent application in the U.S., assuming you're in the U.S. Whether it's provisional or non-provisional, it starts a 1-year time clock on it. That 1-year time clock is the deadline to both file, if you have filed provisionally, to file a non-provisional, and to file in any other country if you want to get the benefit of your initial U.S. filing date. And so frequently what we do is right before that 1-year period, we'll file what we call a PCT application, that's Patent Cooperation Treaty. That's one mechanism of a number of mechanisms for preserving your international filing rights. It's often the most cost-effective way of doing it. The other major alternative is just file directly in different foreign countries instead of filing PCT. That often gets more expensive. What Lowell was referring to is the fact that in the U.S., you have a grace period for your own disclosure of the invention, public disclosure or sale of the invention. So if you disclose it to somebody without an NDA, or you release a product, or you have a press release that talks about the inventive details, you still have 1 year to file a patent application. Now, it doesn't mean it's a good idea to wait 1 year. But most foreign countries don't have any such grace period, so you've essentially blown your foreign filing rights if you had not filed your patent application before that disclosure.
That is something that people blow all the time. Really, really sophisticated people blow that issue all go past it all the time. So you guys are now well educated, well armed. Don't let the common knowledge that you get a year. If you have the money and you have the desire to have a really global business and a really global IP strategy, you gotta make those foreign filings before public disclosure.
So does that, if you have a non-disclosure agreement with the VC, or you go discuss it before you filed your non-provisional patent, is that considered public disclosure? Does that start the clock?
If you have an NDA in place, then most likely it's not going to be a public disclosure. In fact, disclosing it to a VC without an NDA probably is not going to be, almost certainly is not going to be a public disclosure.
Okay, the other thing to know, you probably all know this, but the patent filing itself is confidential, and until the provisional is confidential, and at what point does it become a public record? Like, can a competitor see? I mean, one of the challenges. We didn't talk about whether to file a patent, but one of the challenging kind of strategic questions is whether to keep it as a trade secret or to file a patent. The problem with the patent is that eventually it will become public knowledge, and somebody who doesn't care about the U.S. law, for example, people who are outside the United States, are going to see it, and they're going to know exactly what your invention is because it's going to be publicly disclosed at some point. At what point in the process does it become public knowledge?
Yeah, it's a really good question, and the good news is that in my experience, very few entrepreneurs are out there searching patents and looking to see what competitors are doing. It does happen, and investors sometimes request it, but for the most part, it's not like the mere fact that your invention gets published doesn't mean that everyone actually knows what you're doing. So the dilemma is whether to let your patent application get published. And so in the U.S., if you tell the U.S. Patent Office, first of all, a provisional patent application will never get published unless you eventually get a patent that refers back to it, which may happen, probably won't happen for years down the road. Now, when you file a regular, non-provisional patent application, if you don't want it to get published, and normally the default would be that it would be published about 18 months after you file the non-provisional patent application. Or, I should say, 18 months after your earliest filing date. So it would be if you file the provisional, then a year later you file a non-provisional, then 6 months after that, the default would be that your non-provisional gets published. Okay? If you don't want that to happen, you have to tell the US Patent Office, I don't want it published, and I don't intend to foreign file this. Okay? That's okay. You can change your mind too and decide to foreign file it, in which case you then have to tell the US Patent Office, oh, I foreign filed it, and then they're going to publish it. Right? So that's the trade-off, is you don't want it published ever. You want to keep it as a trade secret until and unless it becomes a patent. You have to forego any international protection.
I actually did not know that. Learned something myself. All right, so and you started to talk about a really interesting point. We have a lot of big corporate clients, and a lot of times in patent litigation, interesting things come out on the witness stand. But talk about this really delicate topic of trouble damages and what behavior that tends to drive in terms of whether to go and look at illegal patents.
Yeah, so the law in the US is that if you are found to infringe somebody's patent, if you're held liable in court, the judge has the discretion to triple the amount of actual damages. Damages meaning what is the monetary value of the injury that your infringement has caused to the patent owner, right? So there's that actual value, and if the judge found that you're a willful infringer, that can be tripled. The good news, though, is that several years ago, the law basically made it much more difficult to establish willful infringement. It has to be found that you were aware of the patent and that you recklessly disregarded whether or not you were infringing the patent. Which means, basically, that if you had a good faith belief that you didn't infringe, either because you got some advice from patent counsel telling you don't infringe, or that you had a good faith belief that the patent in question was invalid, then you won't be found liable. But the bottom line is, anytime you do searching for somebody else's patents to see what's out there, you create some risk of that eventual finding of willful infringement. If sometime down the road you are held liable for patent infringement, then there's some record somewhere in your emails or in your files that you were aware of it. I think it's a low risk, as long as you do your diligence, where if you find something problematic, you talk to patent counsel about it and get an opinion. But nonetheless, I would usually not suggest you go out looking for other people's patents unless you have a really good reason to do it. Yeah.
Can you be held liable for unpublished, for a violation of an unpublished patent?
No.
Then what good is it?
Well, there's no such thing as an unpublished patent.
Well, you just said if I promise not to get a patent overseas, a foreign, that I can not publish it, right?
Right, but ultimately, if it becomes a
if you're-
patent, it
what?
will be all patents are published. Patent applications are not necessarily published.
In other words, you get more than 18 months. 18 months is the statutory cutoff unless you say I want more. You can, but the most you can ever get is up until the patent is granted. Once it's granted, it's published.
Oh, regardless.
Regardless.
Is there an extension on provisional
Okay.
patent?
But your point, Lee, is totally valid, which is there's a whole bunch of unpublished applications out there. You can never know what's in them. So why the hell does anybody care to do a search? Because you can't find 90% of, I mean, what's going to be the most relevant? Is it the stuff that was, filed probably 6 years ago that's now been published? Or is it the stuff that was just filed yesterday, right? The relevant stuff is the stuff that was just filed yesterday. You're not going to know by definition any of that stuff. So, back to my original point about check the box and not worrying so much. I mean, a lot of people get real sort of like, they come into our office and they're like, well, we need to know if this is patentable, and we need to know, if we have priority and if we are going to be the ones to win on this stuff. We got to go do a big search and tell us if, freedom to operate opinion is what it's called. And that is, I think, not worthwhile. It's incredibly expensive, and just the biggest part of it is, and by the way, we don't know anything about what's happened in the last 3 years because none of that's been published yet.
How much is it to file an unpublished? I mean, not unpublished, but a provisional patent.
So provisional could be $100.
Could be $100, could be $10,000, depending upon
That
what
like
your
30
goal
seconds
is.
of your time.
No, but like I said, I think the sweet spot is 2,000 to 3,000. I think is the right balance of time and effort put into it.
Okay.
So in terms of doing a search though, I've heard that when you file a patent, you often have to reference prior art.
There is an obligation.
There's an
That's the tension.
there's an obligation to disclose material prior art that you're aware of. Right? Material meaning that a reasonable patent examiner might consider it relevant in deciding whether to allow or reject your claims. And there's no duty to actually go searching for it. But I mean, you definitely, if you're aware of something highly relevant, you don't want to hold that back because that comes out in litigation and that can render your patent unenforceable.
I mean, the hard part here, right, is, I mean, you kind of want to know. I mean, you kind of want to know if this is even good, right? If you're going to commit your life to this, you know, startup. So there's a real tension here in terms of, do you really look for, I mean, if you could, I mean, if a half-hour searching on the PTO website would reveal a spot-on, you know, patent in your area, you would just move on to another, you wouldn't dedicate your life to this thing. And so there's a real tension. And a lot of people, you know, again, I would never admit to saying this, but I think a lot of people probably do the searches without ever telling anyone they did the search. You just kind of do the search on your own time, and then when you're asked, no, I'm not a search.
Yeah, question. You know, I guess kind of basically, how important are patents? You know, for example, I've developed a new type of rocket engine in my garage, and I haven't patented it. And then I see somebody else comes along and develops something similar, and so I want to like take him to court. I mean, the judge is a reasonable man. I can show him like, well, here's a video I have on YouTube where I prototyped it 6 months ago. I'm obviously the first person to come up with it. Will the judge rule in my favor, or will he rule? You know, if the guys started the patent process, who would win?
That's where we started, which is the new law, first to file rather than first to invent. It used to be first to invent, you know, but until a year ago,
So
you invented it first. That was where the priority lay. But now you've got to file. You know, have priority.
That's getting a provisional patent, and then you have 12 months to file the patent itself.
That's right.
Yeah,
The
but-
relevant date, the filing date is that provisional date.
But here's what usually happens, right? You file a provisional patent application, and it's got most of what you've conceived of as the invention today. But then a month goes by and you develop the idea further. And then a couple more months and you develop it even more. And often I think the inventors aren't really thinking in terms of, oh, I've got these modifications to the idea, I better call my patent attorney and follow up on this. But that's really important because you often look back on it after a year goes by and realize that what you ultimately want to claim in your non-provisional application may not be supported in your provisional patent application. And you don't get the benefit of that provisional filing date if what you're claiming in the non-provisional isn't adequately described in your provisional. So what I often counsel my clients to do is file rolling provisionals, meaning that every month or so after filing the first provisional, we revisit their ideas and figure out, have they added to it in any material way? Have they taken it down a different path than what they originally conceived of? And if so, file another provisional. And again, it can be done fairly inexpensively. And when you ultimately file the non-provisional, you can claim the benefit of any or all of those provisionals as long as it's within that 1 year period.
Then when you file, is that an update to the existing one, or is that start the clock running again? You're
Well,
6
it's sort
months
of an
into it.
update. No, I mean, each provisional has its own clock,
Yeah.
but as long as you file your non-provisional within 1 year of the earliest one, you can claim provisional, you can claim the benefit of all of those going back 1 year. Yeah. The problem though is once you file your non-provisional, you cannot add to it and still keep your filing date. I mean, you can always file new patent applications that just add one sentence to what you previously filed, but it's a new patent application. So it's really important anytime you file to get as much of that disclosure of your invention in there as you can.
Just a quick question, with the change in law, how does that affect, like, for example, I worked with someone who wrote his PhD dissertation in '79, which basically was the algorithm for T9 texting. So he was taken to court with Sprint and AT&T where they all were suing each other about texting law. So if you release something as like a PhD dissertation or paper, does that predate? Could that consider voiding out any patent that came after that?
Absolutely. Well, that counts for your own invention, your own disclosure. You still have you have the 1 year grace period. However, if the inventive entity, okay, let me try to phrase this correctly. So on your patent application, you may name one inventor or you may name multiple inventors. So let's say you wrote a dissertation on a certain topic. And then you file your patent application and the inventors named are you and one other person. Okay? That dissertation is not considered your own disclosure because the inventive entity is different. Okay? If you were the sole inventor, you'd get that 1 year grace period. So you got to be really careful about that. So never rely upon that grace period. I mean, that's kind of like a fallback, worst case scenario. You have no choice. Right? But never fall back on it. Yeah.
I've been working on a common project for 34 years now. And originally, I was going to come out with this game platform that I'm still working on 34 years later. And I've been building pieces of it over this time. Originally, it was a very advanced technology that wasn't there yet, holographics and all this stuff in 1980. And still the technology's not there. So I've been just building pieces that connect together as an integrated system. And now I'm planning to come out with this, in the next couple of years to be this, here's this. So, yeah, I've been out there in the market. I've been, had different products that are based on this core technology. I'm out of the patent game, right? There's nothing I can do to protect this as I go to a bigger market with it, or?
Not necessarily, because presumably there's nothing that has been out there that's been disclosed or actually marketed of the combination of those pieces, correct?
Right, it's all been pieces.
Right. But what a patent examiner can do, or what an opposing party in litigation can argue, is that those pieces together, which are in the public, can be put together and render your invention obvious and therefore unpatentable. Okay? So that's a risk that you take by delaying, but that can happen anyway. That happens all the time. That's how many patents are invalidated or don't get through the patent office. Is the opposing litigant or the examiner says that here are these different pieces of prior art. It would be obvious to put them together and make your invention. Yeah.
So you were talking about it's not worth going through the patents to see what they are not taking a lot of time on that. So I've had this experience where a company asked me to help the lawyer file this stuff, and it goes to the patent office, and a few months later this thing comes back from the patent examiner. It's got 5 or 6 other patents that he thinks are related to it, and how do we claim that this is not the same as that kind of stuff? So I'm just wondering, is that stuff that we ought have known about, or
No.
the
So
patent attorney
here's-
is blowing smoke at? I mean,
That's exactly what happens every time, but every single patent.
That does happen all the time.
So you apply for a patent and you get your first what we call office action back from the patent office, and about 98% of the time it says no patent for you. Next. Not playing those words. But that's very normal, and essentially they're just telling you, explain to us why your claimed invention is different from these references that I'm citing here. Okay, that's all it means. And we go back and forth. We either argue with the examiner politely to explain why he's wrong, or amend our claims to make them more narrow, or a combination of those things. And sometimes we have to go back and forth a few rounds with the patent office, but usually we end up getting a patent. The question usually is not whether you'll get a patent, but how broad or narrow the scope of your claims will be once it issues.
The 3-year period for getting a patent really has to do with exactly this dance between the examiner and the company over the patent. Because you could get a patent quick if you wanted to just take the examiner's comments and be really super narrow on it. But nobody wants a patent that's super narrow.
It's a negotiation.
So then is the idea that you don't necessarily have to have a completed patent when you start discussion with VCs or with investors? So you're saying you could just start with an idea or something that you get the provisional patent with, and then you start the discussion?
Yes.
And even after a year or so, when you've made a few changes, you've got along, then you apply for the non-provisional patent, and then there's still, I guess, a risk that someone would have done something like that, or?
Well, I think the key is that, yes, it's sufficient usually to file a provisional patent application and then start talking to the investors. But you gotta be really careful and include as much of a complete description as you can of your idea in that provisional. You know, sometimes inventors come to me with like 3 PowerPoint slides and say, file this as a provisional. And I tell them, usually 3 PowerPoint slides aren't gonna cut it. I mean, it's really gotta be, the standard is it has to be an enabling disclosure. The disclosure has to enable a person of ordinary skill in the technology to make and use what you eventually claim. And usually that's more than just a few bullet items.
And then, so usually is there already a working prototype, or is that just sometimes just
You
a
don't need
description?
a working model at
So
all.
just a
You just have to
description.
be able to describe it adequately.
But this is still an area where the two of us are gonna kind of spar a little, because it depends on what your objective is. Again, if you're just taking a check-the-box approach and cheap and quick and dirty, you can do that, and VCs won't give a shit. I mean, in all candor, they just don't know. They're not sophisticated enough, unless your whole play is IP. And then they'll actually hire somebody to kind of go do some diligence on it. But if you've got a good company, all you need is in your slide deck on competition, under barriers to entry, you need to be able to say, we have filed a provisional patent. You really don't need to be very clever about it. But that's not gonna get you a very good patent at the end of the day.
And that makes perfect sense as long as you realize that he's wrong and I'm right. I agree with that completely, but I think it's a matter of long-term focus versus short-term focus, and it's really easy for me as a patent lawyer to say your focus should be long-term, but of course there's the business aspects of getting funding and getting going. Tugging at
one other thing because I think it's really relevant to that point, and it's a very common misconception, is this idea that having a patent is suddenly going to preempt everybody in the world from doing what you want to do, from entering into your business. It doesn't happen that way. Patent wars are about thousands of patents in a portfolio, and they literally stack them up like chips and say, okay, I've got 10,000 patents that is in this area, and you've got 5, so we're going to settle this thing 2 to 1. It's literally sort of ridiculous. And so, if you're going to have a true IP strategy, a company built around IP, you're going to need to spend a crap load of money on guys like this to really, put a buttload of patents out there. So that is down the road. To me, it's not. You don't do that as a startup. You just don't. It's something you do kind of maybe at Series C stage. You start to really build out your patent portfolio in preparation for an IPO, where you're going to want to kind of showcase it and make it shine. Now, all these things are not good patents, not good IP strategy. They're just practical. They're just because of the cash flow and the focus and everything else that takes priority.
So what if you're a startup that's spun out, like you were with a large company, large corporation, and you were doing research, and you have stuff that is patented both in your name and in your previous company's name. Now you've spun out from them, and they don't care to prosecute anyone who's fiddling with those, they don't care. But you're making slight adjustments to moving that idea basically slightly different. Is there room there to adjust the patent, or to make a secondary patent that's yours in the company that doesn't, is there a way to separate that at all without just trying to buy it from them outright?
You're getting into a really sort of complicated area of licensing, which is sort of partial ownership, where you kind of sort of figure out who's going to kind of own it.
Licensing is usually the only way to remove it.
That's how you split up, control and ownership and use rights and economic benefits and so forth.
And that just makes it more complicated when it comes to explaining to investors where they put
Yeah.
That's right.
So VCs don't sign NDAs as a rule of thumb. How risky is it to share your idea with a VC? It's a unique idea that is much needed in the market. That VC is involved in that market. How risky is it to share your idea with them without any protection whatsoever?
In my opinion, not very, because it happens 99% of the time. Ideally, you file at least a provisional patent application before you talk with the investors. But if you can't, if it's a reputable VC, I wouldn't worry that much about it.
But that said, I mean, even for me, I mean, our startup package really is intended to start at the beginning. Like before you've talked to investors, before you've had any public disclosure, you, by definition, probably talk to some co-founders and you kind of have to give a little bit. There's always an interesting question of, you know, how much do you tell somebody, because those guys aren't signing NDAs either. You know, but that goes on, and that again, that's, as Jordan says, you just have to sort of be a little bit pragmatic about the fact you have to talk about your business to people. I mean, it's the only way to get a co-founder, so you have to do it. But that said, you know, our sort of fee package, our model is, you know, get the company incorporated, get the provisional on file, then, you know, then we're ready to start sending your executive summary around to VC and talk about, you know, get meetings after that.
Typically, how much does it cost for a startup package?
So I mean, the Perkins Coie startup package is a $10,000 fee deferral for 1% of the equity, and basically that's enough to get all these things done, you know, that need to be done sort of before you start talking to investors.
And then when do you want to roll out an NDA? I mean, when you're talking to, because to me the NDA, the trail of NDAs kind of protects the company. So that when you go to investors, you're like, well, how much talking have you done? And you have a bunch of NDAs. You say, well, we've talked to people, but we're covered under NDAs.
I mean, to me, NDAs is really something you can get strategic partners to sign, as opposed to financial investors. So, you know, it is important. It's really important to try to get an NDA in place for every discussion you have. You know, potentially even including, you know, that first key hire. You know, if you're going to go talking to somebody who you'd like to be your CTO, you know, who has a deep expertise, domain expertise in what you're doing, and you're going to sort of share a little bit of a secret sauce with that person before they come on board and sign anything. You know, that's probably where you want to sign an NDA. So the difference between an NDA, right? The NDA is what you do. All it is a non-disclosure agreement. It's simply, I agree not to disclose. It's not an invention assignment agreement. It doesn't say, I'm going to, whatever we talk about, you own. There's nothing in there in the NDA that says that. The only thing it says is whatever we talk about, I won't share with anybody else. Or use. That's a very good point. And that's right. It's a very good point. So, and oftentimes we end up having to sort of use that clause almost like an invention assignment provision to sort of keep somebody from actually going and you know, competing with the company after the fact. But the basic point is, you know, the NDA is intended to be light enough that people can sign it, you know, and they're not really giving up a hell of a lot by signing it. So you should ask people to do it, and they should do it. As Lee says, VCs just don't, because, you know, they're VCs and they don't have to. But everybody else should do that. And, yeah.
Would it be important to, or how important is it would be to incorporate versus sole proprietorship before approaching a VC?
Well, it depends on who your investors are. My mantra is, you know, Delaware C Corp, provisional patent on file, maybe a trademark on file. These are the basic housekeeping things you should be doing before you're out there really talking to VCs and before you're out there really, you know, getting money lined up.
Is that the same process if you have a clever idea and you're more interested in licensing it than starting up your own company?
You know, licensing, I wouldn't say is all that important to have an entity. It depends on, to me, the entity really, an entity you want to have to shield you mostly from liability. And so, you know, one of the things that I usually coach people on is, you know, when do you actually really pull the trigger on the incorporation? Because you don't want to incorporate every, you know, cockamamie idea you've got, right? You'd have 1,000 corporations. So when does it make sense? The three trigger points to me are, you know, kind of when your first employee is on board, you don't want to have employer-employee liability on a personal level. When you start selling to the public, you don't want product liability on a personal level. Or when you're raising money and you put money into something, it should be into a corporation. So you can get away with a lot before that, but those are the 3 points at which you probably have to decide to have an entity. If you're doing a licensing gig, you may be able to get all the way down to the point of selling the license to somebody as a sole proprietor and never have to worry about an entity. You know, the problem with the Delaware C Corp is double tax. I mean, it's a new layer, it's a new tax barrier you impose between you and your payday. So the only reason you do it is because VCs have to have that. They're set up in a way that the way their funds are set up is they have to have a so-called blocker, they have to have a tax barrier interposed.
But then you'd still go the path of getting the patent and that sort of thing before you start a discussion with other.
And the patent is always an individual. It starts out that way. So that's why the invention assignment agreement is important, because the individual who is the inventor has to assign it to the entity. He literally has to do a physical assignment at the PTO office to you know, it's sort of a bizarre thing, but a corporation doesn't apply for a patent.
As you're talking about as a sole proprietor, kind of considering the pros and cons of organizing as a C Corp versus not at all, could you maybe say a little bit about what if they decide to incorporate as a single member LLC, for example?
Yeah, and that's another way to go, and again, it will depend on who your investors are. It'll depend on how tax savvy you are. If a single member LLC, you know, has all the benefits of, you know, the corporate shield and the liability protection, it's a nice insurance policy against liability, so it's not a bad idea. And you know, if it's a single member, then there is no double tax, so it's going to be a disregarded entity from a tax point of view. So single member LLCs are great.
So why would you not do a single member LLC versus not incorporating at all?
Only because of the hassle factor, and it costs a little bit more to do that, right? And if just keeping it in your own name for a period of time until you're ready to incorporate is probably less expensive in the long run. And if you really have no liability, you know, because you haven't hit any of those 3 trigger points, you probably don't need to do it. But you know, yeah, if you get to one of those trigger points and you really still don't quite want a corporate entity, maybe you do put up an LLC at that point.
Okay.
Lowell, you'll be around for the next couple of minutes.
Sure, yeah.
All right, I think that's, we thank our speakers.